Congratulations on your either engagement or marriage. We're always really excited when we have new couples coming on board. As you probably already heard, our immigration firm devotes itself specifically to couples. So we are super excited to be on your journey here with you today. I want to talk about the 4 most common ways that you might consider applying for a marriage-based green card. So it's kind of crazy to me that there are 4 different ways to do this. You would think there's a way to do this, one way, but that's just unfortunately not how our government system's set up for various different reasons. But we do have to work with the system as it exists. So let's get you some basic information about those different processes. So this video is going to talk about just an overview of each of those different possibilities. Depending on the details I give you now and your own situation, you might be able to rule out 1 or 2 of them straight out of the gate and say, well, no, that's clearly not the right one for us. And you don't even necessarily have to watch the follow-up, more detailed videos about each of the options if they don't pertain to you. I mean, you've got enough stuff in your brain, no need to fill it up with a bunch of other stuff. But certainly, if you can narrow it down to a couple before you get to the consultation, that can be helpful, and then you can really focus in on your time with the attorney and figure out what remaining option is best for you, or what each of the possible scenarios would look like. So the 4 different options are, first of all, there's something called a fiancé visa. That is for people who are not yet legally married in any country in the world. So this, if you've already gotten married either in the US or abroad, then, as an actual civil ceremony, then this isn't going to be an option for you anymore. But if you are not yet married, this is something to consider. The basic idea behind the fiancé visa is that the fiancé visa is a type of visa that allows the foreign fiancé to travel into the United States so that you can either get married right away, or you can stay in the US lawfully for up to 90 days if you want more time to spend together or live together or date, or maybe the immigrant hasn't ever been able to come to the US in person before and wants to check it out before you make a lifelong commitment to live here. So it gives you up to 90 days. And then at that point, you would apply for a green card after you get married here inside the United States. So the fiancé visa is an option that's good when the immigrant lives abroad, you're not yet married, and you are looking for, what's the fastest way I can get them to join me, me being the US citizen partner, what's the fastest way for the immigrant partner to come into the US and actually start being together. And so if that's your priority, a lot of times a fiancé visa is the top choice for that reason. So that's option 1, fiancé visa. So the next option is it's called adjustment of status. And this is a type of marriage-based green card application. So it happens after you're already legally married. And the main requirement for this is that the immigrant is actually already physically inside of the United States. And usually they have to be inside of the United States in a lawful status, so without some other type of visa. The most common, other visa types we'd see are things like maybe you're studying at the university and you have an F1 student visa, or maybe you are working here with an H1B or something like that, would be some common ones. So it's the type of visa that's used when you're already here in the United States lawfully doing something else for a different purpose. You actually end up getting married here and wanting to stay and get a green card and live here permanently. So this can be a great option if you're in that situation. There are some complicating factors if you have recently entered the United States with a visa, and it can also be sometimes done in cases when you have stayed past the amount of time the visa actually was given to you for, or your stay. So if you've overstayed in some scenarios, you can still do an adjustment of status. Most people who are undocumented and have entered the United States without any status at all are unable to do an adjustment of status, even if they've lived in the US since they were children. And so there are some more specific videos addressing those issues and adjustment of status if that seems like it might be an option for you and those are concerns. But so that's what basically adjustment of status entails. Adjustment of status does give you a way to apply for temporary work authorization. and also a travel permit so that you can travel internationally if you need to while the case is pending. But it does take about 3 months, but sometimes longer if they're backed up. 3 to 5 months. I always tell people you want to be prepared for 3 to 5 months from the point when you actually submit the application. You have to be prepared to stay put in the U.S. and if you're not already on another status that has a type of work authorization, you also will have those 3 to 5 months where you're waiting to get to actually get your work authorization. So sometimes that's an issue for people. But so that's adjustment of status. We've got Fianc Visa, adjustment of status, and then the next option, the third option, we call consular processing, or sometimes people call it a spousal visa. And this is an option where there are a couple of different scenarios in which you would choose to do consular processing. One of them is if the immigrant lives outside of the US and you're already married, so you can't get a fiancé visa because you're already married, then this is the way that you would have to go about getting the green card. And basically, there are papers that are filed here in the US, but the main part of the application ends up at a United States embassy in a foreign country, typically the home country or the country where the immigrant is legally residing. If you happen to be living in a third country, then they actually go in person for an interview at the US embassy and are issued a visa, and then they can travel into the US, and they actually give you the green card once you come into the United States. But from the moment you pass through customs, if you've got a spouse visa, then you will actually be considered a permanent resident. So right when you come in, you're able to work and get a social security card and start getting your driver's license depending on what state you're in and things like that. So that's what consular processing is. The other scenario in which we see people need to consular process is if they live inside the United States, but they have some legal complications that prevent them from being able to adjust their status. Sometimes they also have to consular process. So we have a lot of people who they actually do live in the US, but they are going to have to travel back to their home country for the interview at the embassy abroad to resolve other legal issues that they have. And we'll go into that a little bit into these videos. And if that's your specific scenario, then obviously that's probably what most of your conversation will be about during the consultation with the attorney that will be working with you. But so that's what consular processing is. And then the final fourth option, it's becoming significantly less common based on some administrative decisions by the US government. But it's called direct filing, and they're saying direct filing with a US embassy abroad. And it's similar to consular processing, but it's much faster than consular processing. And the reason it's done is when not just the immigrant, but the immigrant and the US citizen petitioner both actually live in the foreign country. So, I mean, this is a fairly common scenario that a US citizen would be living as an expat abroad. They meet someone local and they end up falling in love and getting married. And at some point they decide, okay, we're going to move to the United States. So how do we get a status? Well, you consular process, but if the US citizen's living abroad and planning on also moving to the US with their spouse, in some US embassies, there's the possibility of just starting the whole case and doing it in basically shortened steps. It's much faster than consular processing for administrative reasons. And so it's a really great option if you're in that situation, but it's becoming less common because a lot of the offices that are required to do that, you need a special type of office to actually even be able to direct file. Not all US embassies are equipped, even if they are providing visas. Most of them don't actually have the right type of office to be able to do a direct file, and many of those offices are being closed now as a decision from the United States government. So that's becoming less common, and your ability to do that will depend entirely on whether you happen to live in one of the areas that's still served by an office that does direct filing. So if you live abroad and you can't do direct filing, and you would either, if you're not married, you might want to consider a fiancé visa, and if you already are married, then you would just do traditional consular processing like everyone else. But if you have that opportunity, it's faster, so we try to go for it if it happens to be available to you. So those are the 4 potential ways that you can go about doing this immigration process to become a green card holder and eventually, if you want, a U.S. citizen of the United States. So hopefully, one or more of those kind of piqued your interest, and you can watch the follow-up videos and start narrowing it down a little bit more about which option is best for you.